Hi, good morning, everybody. My name is Romy Jurado. I'm an attorney. I've been an attorney for over 13 years now. So our firm, it's located in Miami, but we do help clients all over the world regarding immigration and trademarks. And we help clients all over the state of Florida regarding real estate, probate, and estate planning. So if there's any questions in those areas of law that you may want to discuss, feel free to put them in the chat. Today's class is how to successfully represent the buyer of a business. So it's not the one of it being sued, but we will talk about that. So I do a lot of business transactions. We help clients either buy a business or sell a business. We handle the legal side of it. The realtors handle the finding the business or the listing of the business. There are no form contracts in the Miami Realtors or Broward Realtors websites. So there are no real forms that you can use. And it always depends on the type of transactions. So for buying or selling a business, it's so important to understand, one, there are no form contracts. And two, it really does depend on that transaction. It's not like selling a property where it's always the same. Today's outline of the class is we're going to talk about a non-disclosure agreement. Why is that? And why do buyers need to sign that? We're also going to talk about how buying a business can actually lead to an investment visa. The importance of a letter of intent. What is that? How does it play a role in helping somebody buy or sell a business? Understanding the asset purchase agreement, because most of the time in the transactions that you'll be involved, it's going to be an asset purchase, and I'll explain what that is. What happens during the due diligence period, which is such an important period for anybody buying a business, the essential steps to a closing, and the use of non-compete and non-solicitation agreements when buying a business that will protect the buyer after closing. So, as I stated before, helping somebody sell a business, it's not like helping somebody sell a house. When you help somebody sell a house, everybody can see the house. It's public, really, an appraisal of the house. There's nothing really hidden. You can just go see it, get an inspection, and you know what you're buying. There's something title insurance that protects the past, so you really know what you're getting into, or at least you should. When you're buying a business, you don't really know what you're buying. So one of the ways to know what you're getting yourself into is to ask the seller to provide to you financial information of the business. Who are the vendors? Who are the customers? How do they do their marketing? How do they do their accounting? And everything else about that business. So essentially, the seller is telling you how to operate and run the type of business that they're having. And what we wouldn't want if we're representing the seller is for the buyer to just get all this information and literally start a new business doing the same thing the seller was doing and not buy the business from the seller. In order to protect that, we, if representing the seller, we have all buyers sign what is called a non-disclosure agreement. A non-disclosure agreement, NDA, confidentiality agreement, is a legal contract, okay, where a party, in this case will be the buyer, it promises to protect the confidentiality of whatever is disclosed to the buyer. Okay, so how the seller gets the clients, how they deal with the vendors, where they get their supplies, how do they do their marketing, what their numbers look like. All that information is going to be given to the buyer, and the buyer should not be able to disclose that. And also, if we're representing the buyer, then we want a mutual non-disclosure agreement, because the buyer may disclose some information to the seller that we would not want the seller to disclose to anybody else. So we're representing the buyer, we would want a mutual non-disclosure agreement. If we're representing the seller, then we just want the seller to be protected. Again, in a business transaction, a non-disclosure agreement is so incredibly important because the potential buyer is going to see financial records of the business, okay? The seller does not want to disclose all those records unless those records are protected. The NDA ensures that any buyer who is giving access to financial or proprietary information disclosed by the seller will not disclose that information to any party who also signed an NDA, or will not use it and now set up their own business and not buy the business that supposedly they were going to buy from the seller. What are some essential parts of a non-disclosure agreement? Well, we're going to have the location, the name, the type of business, the length of time. Is it 2 years after they, signed it? Is it 3 years? Who is going to be a party to this agreement? If I'm representing the seller, I would want the buyer and any affiliate of the buyer, right? If I'm representing the buyer, I would just want the buyer to be bound by it, but not any affiliate. And we also want to list what information should not be disclosed. Is it just financial records? Is it contract with suppliers, contracts with vendors? Is it information about the staff? So we want to ensure what information we don't want disclosed. The non-disclosure agreement is going to keep the business you're trying to buy safe from those posing as buyers and from disastrous consequences of a breach of confidentiality. If you guys are realtors, are listing businesses for sale, you want to ensure all buyers are signing non-disclosure agreements, because otherwise they can just use that information and not buy the business from the seller. If you're representing the seller, that's something that you can tell the seller that you're going to do in order to protect their interest. One thing also that I want you guys to remember, now there are new disclosures, new requirements regarding commissions and all these things. That should not be applied to business transaction as far as I understand it. So for now, we're still good the same old way. Now, a lot of clients in South Florida and Florida are going to want to buy businesses in order to seek some type of visa. And here you guys as realtors will be, I guess, benefited from understanding what potential visas can they obtain through the purchasing of the business. The three main visas that they can obtain are the L1 visa, the E2 visa, and the EB5 visa. I'm going to give you a short overview on each one. I do have a longer class on it, but just so that you guys have an understanding. The L1 visa allows a citizen of any country, Peru, Venezuela, Guatemala, any country, to come to the United States as either an executive, a manager, or somebody with specialized knowledge to set up a business in the United States and be able to live and work for that business. After that business has been operating for a year, that person can apply for permanent residency and eventual citizenship. This visa is great because it's going to include the investor and their family and children under 21. For immigration purposes, your family is your spouse, legally married, and your children under 21. The L1 visa requires that the person that's coming have worked for 1 year out of the past 3 years in a company abroad, and that company abroad is the one that sets up a subsidiary in the United States to send that person to come and work here. What the company did abroad and what the company did here does not have to be the same. So abroad, the person could have run a law firm, and then here they decided to buy a daycare. Abroad, the person could have run a chain of restaurants, and then here the person is working with a chain of stores. The industry does not matter. It does not have to be the same for the L1 executive or manager. What matters is that the person that's coming in have worked for 1 year out of the past 3 years in the company abroad. That company abroad has to have a corporate relationship with the company here. And that is something that we set up when we set up the company here. And then the company here has either to start a business from scratch or acquire a business. And that is where you guys come in helping people buy a business, because any business can qualify for an L1 visa as long as that business needs at least, I would say, 4 or 5 jobs. If that business needs at least 4 or 5 jobs, then you would be able to qualify for an L1 visa. The L1 visa, it's going to give you a way to stay here in the United States for 1 year, and you can renew it for an additional 2 years. And after that year, that person and their spouse and their children can apply for permanent residency. The investment amount, it's really not a high investment amount. I have clients that bought businesses for $200,000. I have clients that bought businesses for $150,000. It's just whatever the business costs. The key is to have at least, I would say, 6 or 7 employees in the company abroad, and to have 6 or 7 employees in the company in the United States, and then you'll be able to apply for an L1 visa. The next visa I'm going to discuss is an E2 visa. This is a very popular visa. Why? Because the investment amount is very low. I have done E2 visas with $60,000 of investment. I know it says 100K, that's usually what we recommend, but in reality, I have done it with 60,000, 70,000, especially for European and Canadian countries, and countries in Europe and Canada, most of the time. Any business would apply for this, right? So that cafeteria that you have for 100,000, the store that you have, the doggy grooming business, any business, as long as it's a legal business federally. Why do I say this? Because I have clients that have come to me, and realtors, business brokers that have asked me, Romy, can we do, a dispensary type business? And I said, no. Why? Because while it might be legal in your state, that type of business is not legal federally. So it just has to be a legal federal business, any business, and the investor has to own at least 50%. I recommend 51%, okay? But at least 50% and be in control of the business. So the investor, in order to qualify, has to be a national of a treaty country. I have a list of all the countries that have a treaty with the United States. And the investor has to be a national of that treaty country, meaning possess a passport. Then the investor has to invest a substantial amount. What that amount is, it depends on the business. If it's a cafeteria for $60,000 and that's how much it costs, and that's a substantial amount. If they're going to open a 5-star restaurant and the restaurant is 600K or $1 million, then that's a substantial amount. If they're going to do a real estate managing business, meaning they're going to manage real estate for others, and all they need to do is invest in a website, in an office, maybe around 100K, then that's a substantial amount. So it just depends on the type of business. Here, the main thing is that the person be of a treaty country. The whole family does not have to be of a treaty country. For example, Peru, where I'm from, it's not a treaty country. But a lot of Peruvians may have Argentinian citizenship, who's a treaty country, Colombian citizenship, who's a treaty country. And even though just the investor has it, meaning the father or the mother, the whole family will be included, because as long as the investor has it, all of the family is included in that package. E2 visas are granted depending on the country that you're from. For example, in Mexico, it's 4 years. In Argentina, it's 5 years. In Colombia, it's 5 years. And in Canada, it's 5 years. And you can renew this visa indefinitely as long as the business is going forward, okay? This visa allows the investor to work for that business. Their spouse can work for wherever he or she wants, and their children can go to school here. Now, this visa does not lead to a green card directly. However, I have clients that have started with an E2 visa because of the lower investment amount. They bought a business, let's say, for $200,000. And then eventually they invest more in the business, right? Up to the amount of 800,000, and I'll explain that now, or $1,050,000. And we're able to use this business, this E2 visa business, in order to apply for an EB-5, which does give you a green card or residency. And I'm going to talk about that now. Also have clients that came in with an E2 visa. The investor worked for the business and their spouse went to work for another business, let's say a small accounting office with 5 employees. Well, the person did a great job and that accounting office wanted to do a labor certification. And now that person is going to obtain permanent residence. And when they do, it's going to include all their family. Maybe that person wouldn't have gotten that opportunity if he or she wouldn't have been able to work freely for that business, because a lot of businesses don't want to do sponsorships from the get-go. And with an E2 visa, you're able to work with whoever you want to work for without a sponsorship, because your spouse is managing the business and you're free to work for wherever you want. Okay, the next visa that we have, which is a very popular visa, is an EB-5 visa. An EB-5 visa is a straight shot to permanent residence. An EB-5 visa allows a foreign national from any country to invest in the United States and help create 10 full-time jobs, either directly or indirectly, in order to be able to obtain permanent residency for themselves and their family. The main purpose of this EB-5 visa is to create employment. Okay, let's keep that in mind. Create jobs. Now, there are 2 ways to do an EB-5 visa. One is through investment in what is called a regional center, and the other one is through investment, direct investment. When you do it through a regional center, basically, these are private institutions that have obtained a qualification from immigration to receive foreign investor money, give it to the projects, and then in exchange, that foreigner receives a green card for their family and themselves. You can also do direct investment, which means you are the one that creates the company or buys the business. You are the one that creates the new 10 full-time jobs and you manage the whole business. In either way, the investment amount, it's going to be at $1,050,000 anywhere, or $800,000 if it's unemployment or rural area. So the investment amount is always going to be $1,050,000 anywhere, or $800,000 if it's a rural area or a targeted employment area. So what is a rural area? It's an area outside a metropolitan statistical area or outside the boundary of any city or town having a population of 20,000 or more. And an area of high unemployment is an area experiencing unemployment of at least 150% of the national average rate. The length of stay, the way that it works is first, the investor puts in the money, the $1,050,000, let's say, and then the investor receives what is called a conditional green card. That conditional green card is good for 2 years. After those 2 years, or during those 2 years, the investor has to show that the 10 full-time jobs were created in order to receive the permanent green card, and then that's it. They're no longer responsible of renewing, of continuing with the business if they don't want to. However, if they did it through a project where they don't manage the business themselves, then that's going to be regulated by wherever the investing documents say of when they get their money back. And I can go into more detail if you have specific questions for EB-5, but just know that buying a business and investing in a business can be used for for an EB-5 visa and can lead to permanent residency if structured correctly. So now that we have a little overview of the different visas, let's go ahead and talk about the actual purchasing of the business. So first, there is a business for sale, right? So if you're the realtor, business broker listing the business, you have talked to the seller and you said, okay, let's list your business for this amount. And the seller has agreed. And now you've put it on the MLS or you listed in buy and sell, wherever you put it to advertise the business. And you're going to be receiving probably most of the time a letter of intent, okay? So a letter of intent basically is a letter that acts as a blueprint for drafting the final deal documents. It should help both parties reach an agreement. A letter of intent is an agreement to agree. It's basically bullet points of what the buyer is willing to accept that is presented to the seller, and then the seller says, I agree with this, I don't agree with this, I agree with that, and then they will go into drafting the final purchase documents. In the letter of intent, some of the things that we're going to include are, for example, the purchase price, right? Because you may have listed for a price, but maybe the buyer is offering something else. We're going to include some confidentiality clauses. We don't want the seller to use this letter of intent to try to find other buyers saying, look, I'm getting this much for my business. If you give me more, I will sell you the business. We want to describe what the purchase assets are. What is it that the buyer is buying? We want to specify termination period because maybe the letter terminates if we don't enter into a final agreement. We want to say what law will govern this agreement and what is the venue. Is it Broward County, Dade County, where at? We want to specify if there's any liabilities that the buyer is going to be assuming and any conditions preceding to a closing. What is it that we need to do in order for the buyer to close? Most of the transactions are going to be an asset purchase agreements from what I've seen, but you could also help somebody buy the whole company. Meaning if it's a corporation, then the buyer would be buying through a stock purchase agreement. If it's an LLC, then the buyer would be doing a membership interest transfer agreement. This is where the buyer buys the whole company or a portion of the company, and they step right into the shoes of the seller in terms of responsibilities. Because when you buy the whole company, you know, your liability is not limited really because you're now owner of the company and the company is going to be responsible. There are documents that can be drafted to have, you know, further protection, such as indemnification agreements and so forth. But most of the time, the buyer needs to understand that when you buy the whole company, you are acquiring a little bit more of liability. Now, like I was saying, most of the transactions are going to be through an asset purchase agreement, where the buyer has their own company and they acquire substantially all of the assets of the seller. An asset purchase agreement provides for the sale of tangible and intangible assets and liabilities of a seller to a buyer in return for cash or some other form of consideration. The asset purchase agreement, it's going to say what documents would be prepared for closing. For example, we're going to be preparing a bill of sale, an intellectual property assignment, an assignment and assumption of agreements for contracts and permits, an assignment of the lease, right? The asset purchase agreement, it's going to say what are the acquired assets? What is it exactly that you're acquiring? What are some of the assumed liabilities? And you really want to enumerate what those assets are. An asset purchase agreement is also going to have representations and warranties that, you know, say what is it that the seller is representing so that the buyer can come after the seller if something happens after closing that was not disclosed. Here you will see a little bit about what we include in an asset purchase agreement. Again, there are no form contracts. This is a total negotiable document. What liabilities are going to remain, what indemnification, meaning what protections the seller will give the buyer after closing, covenants, the non-compete, all of these things are fully negotiable. Non-competes for the seller are fully enforceable. I know you guys probably heard about a recent regulation that was going to come into place in September 4 that was going to make non-competes no longer enforceable. That was still not going to apply in the case of selling of a business, because when a seller sells their business, they are selling their ability to be able to do that business. And if they are not signing on that, right, they're not saying, I will not do this same business within a certain mileage or within a certain county or something like that, then they can just open shop, run in front of the buyer, take all the customers, take all the clients, and then compete with the buyer. And then what did the buyer really buy? A non-compete is extremely important with representing the buyer, because you want the buyer to be protected from the seller basically taking all the customers and clients and doing the same business. Some other things that are really important are the due diligence. So first, either the letter of intent is created, and maybe we have an asset purchase agreement that sets out a period of due diligence. During this period, it's so important for the buyer to do legal due diligence and financial due diligence. There is no title insurance, right? So when you buy a property, you get title insurance that says we are insuring up to the amount of the purchase price, that nobody's going to come and make any issues regarding this property. And if they are, either the insurance company is going to provide you an attorney to defend, or it's going to give you money up to the amount of the purchase price. There is no title insurance with buying a business. Okay, that is why due diligence is so important. Due diligence is the period immediately after the execution of the asset purchase agreement. Sometimes it could be after the execution of the letter of intent, that allows the buyer and the buyer's attorney to conduct their independent legal research and investigate the validity of the business. This time period is very crucial in determining if the business is the right fit for the buyer. The duration of due diligence is going to depend on the type of business. When we're dealing with regulated type businesses like insurance companies, pharmacies, medical practices, dental offices, law firms, accounting offices, med spas, even anything like that, or anything regulated by the federal government, we would want a longer period of due diligence. If it's just a restaurant, then I'm okay with like 15 days. That's fine, because those are, easier. Or if it's a boutique or a nail spa or a hair salon, maybe a shorter due diligence is okay. So what do we do during the due diligence? So we conduct legal research on all parties associated with the transaction, including but not limited to searching on the following databases. We search the Florida Secure Transaction Registry, Uniform Commercial Code. These are UCCs. Why? Because if you have a seller and he got a loan from the SBA, it should be recorded there in the UCC. So we need to, as a UCC, so we need to find out how much they owed in order to get that paid at closing. If they got a loan for an advance on their payroll, or an advance on their accounts receivable, or if they got a loan to, you're selling a gym, but in reality, all of the machines are really financed. All of that should appear in the UCC. Or if they got a loan, a personal loan, but they gave their business as security of the loan, all of that should be in the UCC recorded. And we want to ensure that when the buyer gets this business, it's free and clear from any of those things, because otherwise, what is the buyer really getting? We also check the Florida Department of State for any type of liens recorded against the business. We conduct, and also for judgments, we check the Department of State for judgments and liens recorded. The clerk of courts, we search the seller, and we also search the seller as a person, because there may be judgments or there may be an active lawsuit against the seller. We search for the business tax status in the county and the city. We also ask for the county tangible tax status. If applicable, we conduct a comprehensive asset search. If we're dealing with businesses that collect and remit sales tax, who collects and remits sales tax? Every time you're charged either at 6% or 7%, restaurants collect and remit sales tax to the Florida Department of Revenue. Restaurants collect and remit sales tax. Food trucks collect and remit sales tax. So we check those sales tax for the Florida Department of Revenue. We get something called a sales tax clearance to make sure that everything has been satisfied. Because if it's not, the position of the Florida Department of Revenue is that even though you're only buying the assets, you are still responsible to satisfy that. Otherwise, they will not give you a sales tax certificate in order for you to run your business. So we check that also. Again, buyers and sellers are free to ask any questions to try to complete your transaction. There is a certain type of due diligence that I cannot do, which is like looking at the foot traffic. I recommend my buyers to literally go sit outside the business, take a look at who comes in, who comes out, so they can truly understand what they're buying themselves. And during this due diligence period, the deposit should be fully refundable, so that in the event that the buyer finds the business no longer meets their needs because of an inspection finding or any other reason at all, they are able to terminate the contract without penalty of losing their money deposit. And this period also protects the seller, because once due diligence is over, if the buyer decides that they no longer want to buy the business for whatever reason, seller is able to keep the deposit, right? And then the buyer loses it. So it's a period that protects both the buyer and seller to ensure a smooth transaction. All right. Closing preparation. So the closing process, right? So we're in the closing process. We have to finalize the purchase price. There might be some adjustment to the purchase price, maybe due to inventory, or maybe because there was a loan that needed to be paid, so now the purchase price is going to be less. Whatever it might be, we ensure that that's taken care of and that we adjust the final price if needed. We also prepare government documents, any type of filings that need to be done, either to assign the trademark or to start a new doing business as or fictitious name, whatever it is. We confirm insurance requirements. Maybe the landlord of the business that you're buying, the location requires insurance. We prepare any furniture or equipment list, what are the assets that are being transferred. If there's any contracts that need to be transferred, that needs to be done as well. The lease transfer, that's important during the closing preparations. We prepare all the closing documents, such as the bill of sale, the closing statement, and we finalize the asset purchase agreement if it hasn't been finalized yet. Once that's all done, then we schedule the closing. We make sure that all the funds are transferred. The deposit is usually given to the attorney that's handling the closing, and then the funds to close are also given to the attorney that's handling the closing. If this transaction, it's going to be a finance transaction, then the bank will give those deposits to the attorney that's handling the closing to disburse after all the conditions of the bank had been satisfied. We finalize the asset purchase agreement if it hasn't been finalized yet. If it's one that's going to be signed at closing, we make sure that we accommodate any and all adjustments. We finalize the deal, and that's it. The business is sold. If it's an asset purchase, it's important to understand that the buyer needs to now get all of the licenses and permits in the name of their business, because they didn't buy the membership interest of the company or the stock, they bought the assets. So if it's a salon, now they need their state license, their city license, their county license in the name of a business, in their business company name. If it's a restaurant, same thing. So if it's an asset purchase agreement, all of the licensing will need to be done once they own the business. If they did a stock purchase, then not necessarily. As part of the closing process, I had mentioned to you guys that it's so important to have a non-competition agreement. And these are important to protect the seller, okay? So typically a non-compete agreement is a contract between an employee and an employer where the employee agrees not to enter into competition with the employer after the employee terminates or it's terminated. However, in a business sale, the buyer should strive to have the seller sign one for the same reason, so that the seller agrees not to enter into competition with the buyer for a certain period of time, enter within a specific mile radius or counties or the state, depending on how the business might be. We also include what is called a non-solicitation agreement. A non-solicitation agreement is a contract in which an employee agrees, usually the time, agrees not to solicit a company's clients or customer for his or her company. However, in a business sale, the same applies. It should be signed by the seller in order to ensure that he or she will not solicit any of their previous clients or customers for he or her own benefit. So this is important for the buyer to have signed by the seller in order to protect their interest. Somebody asked, what is a UCC? Okay, a UCC is basically a recorded secure transaction. Whenever you get a personal loan, whenever a business gets a loan, a UCC is going to be recorded in the state of Florida to tell the world that that business or that person owes that money, and that it's being secured against whatever it's being secured. In this case, most of the time, it's the assets of a business. So that is a UCC. All right, since I don't see any more questions, I want to thank you all for joining me today. I really enjoy giving these classes and educating you. Please feel free to see me as a resource. My contact information is there. You can follow us on Instagram and Facebook. We also do a lot of different events, both live and through webinars. And I look forward to helping you and your clients grow and protect your business soon. Take care, everybody. Bye-bye.